back. I know you guys are probably so sick of me reading. I know. We only have a few pages to read. This is only like, I think like 3 or 4 pages for Courtney Clenny. And then we're gonna watch a hearing that was only like 23 minutes long. I don't know why. It wasn't even, I don't even think it was online. I don't know where the hearing came from, but it is from Law and Crime. I'm assuming they got it from maybe someone that was there. I'm not sure. Or they watched it on the court website. I'm not sure. But we're just going to touch base on Courtney Clenny real quick. I covered her, I think like a week or something ago. And basically her defense team is trying to get out trying to disqualify the state attorney's office because they were sharing emails that they were not entitled to either share or look at regarding her defense and her defense team. So we read a document, I think like a week or two ago, and then this is their motion. This is a response. So this is the state's response to the motion to disqualify. And what happened is I have a whole playlist on Courtney Clenny, but the prosecution team was, like I said, they were sharing emails. Assistant District Attorney Khalil Quinnan was the one who I think kind of messed this all up. And, you know, it kind of goes back to like the Kohberger case, which we just covered. It's like they have enough solid information, like why jeopardize a possible conviction, right? So we're going to just read, it's a couple pages for Courtney Clenny, and then we're going to watch the hearing. Hello, Torta Pander. Hello, Augie. Hello, Jasmine. Good to see you. I'm going to pull up the document really quick, and then we'll watch the hearing. Again, it's only like 23 minutes. Not sure why it's so short, but we'll just get through it. So this was filed on the 20th. So the same day, Brian Kohberger's motion to continue was filed as well. And we just covered that. Hello, welcome to Mellyverse. If you are new here, we just covered the Brian Kohberger motion to delay the trial. It was a great document. We're going to be covering a hearing from him as well. We have Karen Reed after covering her case. We're going to do like a Karen Reed marathon tonight / Melly After Dark. I'm behind on that due to covering the Diddy trial. So there's just a lot of true crime, but let's get started. This is the defendant's reply to the state's motion in opposition to the defendant's amended motion to disqualify. Defendant Courtney Clenny, through her counsel, files her reply to the state's response in opposition to defendant's amended motion to disqualify the state attorney's office in and for Miami-Dade County for prosecuting the above referenced case. The state, in their response, misstates to this court the applicable law in this matter and glosses over the substantial misconduct that has occurred in this case as delineated in the amended motion to disqualify. To disqualify the state attorney's office, the defendant must show substantial misconduct or actual prejudice. Actual prejudice is something more than mere appearance of impropriety. As stated in the motion to disqualify, the defendant is moving to disqualify the Miami State Attorney's Office on the grounds of substantial misconduct or actual prejudice, which are two avenues stated in the Supreme Court's decision in Downs for disqualification of the prosecutor's office. The state has only argued that there is no actual or future prejudice to Ms. Clenny. Understandably, they have not addressed the substantial misconduct of their office. The state's response attempts to discuss what they have accomplished since the evasion of the defense camp. Although the state's attempts to put the toothpaste back in the tube addresses some of the concerns of the defendant, the state's response fails to address or defend the substantial misconduct. So specifically in defendant's amended motion to disqualify that delineates the misconduct of ASA Quinnan, it is important to note that the entire prosecution team adopted and participated in hearings over the last year and or stood by silently adopting the many shifting positions throughout litigation of this issue. So ASA Quinnan, if you're not caught up on it, he has now since stepped down from this case, which is crazy. And if you're not familiar who Courtney Clenny is the OnlyFans model that ended up stabbing her boyfriend to death, and she is claiming self-defense. Hello, beautiful Augie. That's also a wild case, and it's not as much in the media right now because there's been nothing going on but them trying to, get the state attorney's office thrown out, and then there was a whole charge with the parents and the laptop. That was a whole thing too, where her parents were arrested on grounds that they were trying to break into Christian Sully. That was her boyfriend, Courtney CLENNEY, the OnlyFans model. If you're not familiar with that case, I have a playlist with the body cam footage. I did a deep dive. It's brutal, but that's actually really good body cam footage that I have that I'm really proud of on that case. So make sure you go back and watch. It's the non-redacted version too. So trigger warning. And I think that she was just denied bond again, but I don't know, at this point they might as well give it to her because she's already been locked up for like 2-3 years and they keep messing up. So I don't know, is it fair that she maybe gets bond and gets to be on house arrest, or no? It's one of those things. So let's continue. There is a distinction between private law firms and government. As a result of the distinction, the Florida Supreme Court has recited that imputed disqualification of the entire state attorney's office is unnecessary when the record establishes that the disqualified attorney has neither, 1, provided prejudicial information related to the pending criminal charge, nor has personally assisted in any capacity in the prosecution of the charge. Wow. Here, ASA Quinnen provided prejudicial information relating to the pending criminal charge, and he personally assisted in the prosecution for over a year after having violated the attorney-client and work product privilege. As such, recusal of the entire state attorney's office is warranted because it is undisputed that the disqualified by choice assistant state attorneys in this matter, ASA Quinnen personally assisted in the prosecution of the charge. Not qualifying the entire state attorney's office under these circumstances is repugnant to the administration of justice and creates a well-founded fear of the confidential communications between Ms. CLENNEY and her attorneys will continue to be violated. As stated by the Florida Supreme Court, when defendants no longer have absolute faith that all confidential communication with counsel will remain forever and violate, no candid communication will transpire and the guarantee of effective assistance of counsel will become meaningless. This is too high a cost for society to bear. The state argues that the matter before this court is similar to Nunez versus State 665. However, unlike Nunez, the entire prosecution team has been consulted on the invasion of the attorney-client and work product privilege. The entire team and many others, known and unknown, were consulted on the issue of attorney-client communications from the team COURTNEY chat, and the entire prosecution team actively participated in litigation concerning the clearly privileged email that laid out the entire defense strategy. So ASA Quinnen, who has now stepped down, he was passing emails and sharing emails that were only, for the defense team. Yeah, chief. I know. I feel like they had enough evidence and footage on Courtney CLENNEY and enough to substantiate her being in jail, but I feel like this kind of ruins it a little bit. The matter is more akin to State versus Martinez, where the trial court disqualified the entire state attorney's office after several attorneys listened to jail calls between the defendant and his counsel. The calls in Martinez discussed inter alia the testimony of witnesses, counsel strategy, and other issues regarding trial planning. These are exactly the areas and contents contained in the privileged document that was reviewed by Quinnen and law enforcement at a minimum. The trial concluded that the lesser sanction of disqualification of the individual prosecutors would not suffice because the recordings were heard by a number of attorneys and the contents were discussed throughout the state attorney's office. Consequently, the disqualification of the entire Miami-Dade State Attorney's Office is warranted to provide a fair and impartial trial for Courtney CLENNEY and to protect the integrity of the judicial system. Conclusion. The actions taken by the state are precisely the type of substantial misconduct that warrants disqualification of the entire state attorney's office, as discussed in Martinez. There is actual prejudice as delineated in the amended motion to disqualify. Furthermore, actions taken by the state in reviewing privileged materials rise to the level of substantial misconduct. Under the analysis as discussed in Downs, Ms. Clenney must show either substantial misconduct or actual prejudice. Disqualification of the entire state attorney's office is appropriate as there has been substantial misconduct on the part of the state and or actual prejudice flowing from the substantial misconduct. I hereby certify that on May 20th, I electronically filed the foregoing document. The clerk of the court using the Florida e-portal system. I also certify that the foregoing document is being served this day on all of counsel of record via the online filing system, the Prieto Law Firm. So that was the end of the document. So basically, you know, they're just saying that no, you should disqualify them because they did violate. And they made another point, you know, they were in the team chat and sharing. And I mean, in my opinion, I think they did violate. Hey, Jules. Okay, so let's watch this hearing. It's only, like I said, it's only like 23 minutes long. Thank you for being here, by the way. I know some of you were here from the last live. If you missed the last live, we covered Brian Koberger, motion to delay trial, and now we're covering Courtney Clenney, and then we have Karen Reed left still. So thank you for being here and hanging out on a Sunday. It's my day to catch up on things I've been wanting to do. So
we have defense counsel here, state here, defendant is present. You guys ready to go?
Yes, Judge. Sean Abuhoff on behalf of the state, along with Kathleen Hogue.
And Frank Prieto on behalf of Ms. Clenney. She's present before the court, and also co-counsel Ms. Pugliese.
So we are here for defendant's motion to, or amended motion to disqualify the state attorney's office. I was able to get through a lot of the binder. I've obviously looked through the motions, the response, and some of the case law, but we're ready to go. So defense.
Yes, Judge. You have the binder.
hello,
I know you've read it.
good to see you, Liv.
I haven't read through all of it.
Okay,
That dropped off a day in advance, but I have to
Sure.
read through a lot of it.
sure. And Judge, you know, our written pleadings say a lot. And so I don't think this oral argument has to repeat everything that's already been delineated in our amended motion and especially in the reply. So I'm just going to highlight some things for you. So the standard.
This is her lawyer.
Standard and why you believe you've met the standard and.
Yeah, so the standard to disqualify the state attorney's office is found in Downs versus Moore. And that is the defendant must show substantial misconduct or actual prejudice. And the case law that interprets what actual prejudice means is more than just an appearance of impropriety. But in the reply, well, in the state's response to our motion, they're highlighting most of their conduct that they've done after what I would refer to as the misconduct of the ASA claim. The court is intimately familiar with those facts. You send the deposition, so I don't need to rehash the facts of that particular breach into the defense camp. What the state argues is that look at everything that we've done since. We've sealed the V case off. We've restricted access. I would just note that Mr. Quinn's still on the delivery list for pleadings, but we unclick him to kind of wall him off. But what I think is most important, Judge, is Mr. Abuhoff and Ms. Hogue. It's not what they did, Judge. It's what they didn't do.
Oh,
And what they didn't do,
it's what they didn't do.
which is contained, I believe it's Exhibit A to our motion. Yes, it's Exhibit A. We have a letter. As soon as we realized upon the arrest of Courtney Clenney's parents and the allegations contained within the arrest warrant, it was clear that the state had obtained our work product or attorney-client privileged communications. As recommended by the Florida Bar, as soon as we realized that they weren't in possession of our confidential communications, we sent a letter addressed to Chief Assistant Kathleen Hogue, Sean Abuhoff, and Mr. Quinnen. That first letter was February 15th of 2023.
Hey, not my job.
The response to we was sent via email. The response we received from the state was complete silence. They didn't even acknowledge receiving this. Exhibit B, another letter shortly thereafter, February 28th, 2024, same letter, second request. That was received, sent out via email, and the response to that request for having our confidential privileged documents back or communications was silence. Exhibit C, third request. This one came February 10 of 2025. That was after the chapter 119 revealed the email, the confidential privileged email. We sent the third request again. Ms. Hogue, Mr. Abahoff, Mr. Quinnen, this third request for our work product and confidential communications again met with silence.
Oof,
So
that's not good.
why is that important? The case law that we've talked about in the written submissions talks about substantial misconduct. And what does that mean? The case law doesn't say exactly what that means, but what the case law does say, every case needs to be looked at on a case-by-case basis. So we have to look at the facts of what has occurred in this litigation, and the appellate courts, again, would review that on a case-by-case basis, because every misconduct is, it would, I think, be different. So what we have here is,
I kind of
and the court's
agree
very aware
that the
of Mr.
state
Quinnen's misconduct,
messed up here.
but Mr. Abahoff and Ms. Hogue, they had a responsibility. When they received these,
They have a responsibility to respond, and also ASA Quinnen, although he has stepped down, he had a responsibility to not be nosy and get into emails that weren't pertaining to him or to share. You know what I mean? Again, they have enough information and enough evidence on Courtney CLENNEY to keep her locked up if they want. Now, do you think that Courtney CLENNEY is guilty? Let me know in the chat. Do you think that it was self-defense, or she was just a spoiled OnlyFans model who stabbed her boyfriend when she was drunk or something one day and they were fighting? It's clearly it was a toxic relationship, but
you know what, Frank, Sabrina,
they're also messing up here.
let's look into this. What exactly is it that you think that we have? They didn't do anything. So I believe their misconduct is by omission, which I think the court should consider in combination with the misconduct of ASA Quinnen in reviewing those materials, not disclosing that to the court, which is it's not a two-prong analysis. It's substantial misconduct or it's not and. And what the state relies on is the actual prejudice. They're saying, hey, she
Guilty,
has
yeah,
been prejudiced.
really. Me too.
Nobody else has seen this stuff. But I think the analysis that we think is important for the court to consider is, does the conduct of the state by acts or omissions rise to the level of substantial misconduct? And I think it has. They had an opportunity to do the right thing when they received our correspondence. Hey,
That's
let me
where I'm
investigate
going.
this.
Mhm.
What are they talking about? Let's talk to Quinnen and figure this out. Because if there was something done that was improper, they could have nipped it in the bud right there. And they didn't. So I think it's the combination again, the acts and then the omissions on the part of the state. And I think it rises to the level of substantial misconduct. The appellate court decisions, one that the state talks about is Nunez. We think this case is more similar to that of Martinez versus state, where ASAs heard jail calls between the attorney and the client. And in that case, in the Martinez case, the third district, I think it was the third district case. Fourth. In that particular case, that was affirmed on appeal. So it really is very unique circumstances that we're in. I haven't litigated a case of motion either on the side of the state or defense now 25 years. So it's an interesting topic. But I think that what occurred here, Judge, it's an abuse of discretion standard. I think there's substantial record evidence of what occurred and what should have occurred or didn't occur that would support, Your Honor, disqualifying the entire office. And that's what the defense is asking. The entire Miami-Dade State Attorney's Office should be disqualified.
Right, state.
Yes, Judge. So it's the state's position that the defense is misinterpreting the law on this issue. The defense wants to separate substantial misconduct or actual prejudice. But I think the case law is very clear, and there's a reason why quotations only appear around actual prejudice after the term substantial misconduct. And I think that's meant to define. There's a reason why in all of this, the case law on this issue, it only goes on to elaborate on this actual prejudice and what it is, and not just the mere appearance of impropriety. So that's the major part here. And if you look at all the cases that even the defense cites to, they all come about by some form of misconduct by the state. And the question just comes, does it rise to the level of substantial misconduct? And the analysis all comes down to, is there actual prejudice by the defendant at the time? And is there a fear of potential future risk of prejudice? So I think that's the analysis. And I think the defense, certainly wants to look at this individually and point to just substantial misconduct without a definition, whereas all the case law gives it to us. And when you look at those cases, there are plenty of them that are similar to this. You look at McWaters v. State.
So Quinnen was basically sharing an email with his coworkers or other departments, and they were talking about it and sharing it. That is misconduct from the Attorney State Office. That is
The defense side.
I don't know how they
Supreme
can
Court
get around
2010.
that. It is what
That's
it
where
is.
the state actually even listened to jail calls between the attorneys and their client.
He's
So
talking
there's
about a
some
different case here.
form of misconduct that far
Referencing.
exceeds what this can even be, but that's part of this analysis. And we have to look to and break down both who are the actors, and what is the prejudice that the defendant faces. And the question here is, does the defendant face prejudice right now in the position that she's in, with Ms. Hogue and myself remaining on the case? And then if that is actually true, then the question would then move to the office as a whole. So I can take, and I would argue, Your Honor, that she does not face any prejudice, and we can break down the two breaches that Your Honor has found to be breaches. The first being the text communications. And defense points to these letters that they've sent to us, the February 15th and February 28th, 2023 letters that were received with silence. That's because after this all came about, we had all of this litigation on the issues of whether or not it was protected material on that computer case, that access case. Your Honor took control of those drives, and it's been in your possession ever since. So the idea of being able to turn back over these items, they were not in our possession. So I don't think we can be faulted for not responding to their letters. The content of those letters are important, though. And that's why McWaters becomes an important case, because in that case, in denying the motion for sanctions or disqualification, the court found that there's no evidence that the substance of these calls provided any benefit to the prosecution or were used in a way that detrimented the defendant. So McWaters goes on to explain that when you look at the context of those communications, there was no detriment to the defendant at that time or any future risk, because the calls were what they were. These communications, the only person who reviewed them was Mr. Quinnen in their original format. The world has had an opportunity to review them in the arrest warrant and in the search warrants. And what is clear is that those are just discussing the access of the computers. So there is no prejudicial information within those text messages that either myself or Ms. Hogue have seen, or really anybody in the world has seen. And through Mr. Quinnen's deposition, he did not even see. It was limited to just that. So from the context of just the communications of those text messages, there's no work product, or I should say no defense theory of the case. There's no strategy concerning the homicide prosecution itself. It merely is the access of this computer. That being said, again, myself and Ms. Hogue did not access this. So as we sit here today, there is no actual prejudice that the defendant faces. It cannot, I don't even believe it rises to the level of an appearance of impropriety, but that, even if it did, that is not enough. But I think the analysis really, and the harder question here is now moving to that, and I termed it in my motion, the Puglisi email. What's clear is that no one that is currently on the state's prosecution team had an opportunity to review this. Mr. Quinnen himself did not remember this item because when Your Honor ordered every part of the communications turned over to you, this would have been included. This is part of that. This doesn't come about until there is a public record request. And that is when the defense sends us, once they're made aware of it, they send us a letter to have us turn it over. Again, it's met with silence because we don't need to respond to it, but we do take action in it. And that's the importance. Myself, Ms. Hogue has come before this court and stated that we have not viewed it and we don't plan to view it. And I don't believe anybody in our office could ever view it because I've been able to verify it has been deleted from our servers. So
Wow.
the only person who accessed this is Mr. Quinnen. And in his deposition, what was clear from that was
You can tell
the only
that
thing
her
that he
lawyer
remembered from
said
it
it
was
was,
the
like,
name Mr.
pissed.
Haas, which was their computer expert. And again,
see it.
going towards that investigation, that separate matter. So when you look at that, that is the Nunez case very specifically. It is a person who accessed, an individual who accessed attorney-client information and the contents, and we have no problem with stipulating that the contents would be prejudicial if the state reviewed it. Mr. Quinnen does not remember the contents of it. His only knowledge based on the deposition is the Mr. Haas aspect of it. And so he's also stated in that deposition, we've affirmed he has not discussed with anybody in the state attorney's office the contents of that document.
And he
So
stepped
that
down.
goes to the Nunez case, which in that case, they found based on what the court deemed as misconduct did not rise to the level of substantial misconduct for the office. It did for that prosecutor. They removed that prosecutor, but not the office. So that's why this is not
Oh, okay.
State v. Martinez. In that instance,
So the state's saying, hey, you can maybe remove ASA Quinnen, which he already stepped down, rather than removing the whole office because not everybody saw it, right?
that
everybody
prosecutor, not only that
participated.
prosecutor, other prosecutors heard the calls and were discussing throughout the office. The state has done its proactive work to ensure that the rights of the defendant aren't violated, that the defense team's communications aren't overheard, and we have a filter protocol in place for all of this. Your Honor has been made aware that once and if Your Honor rules to not disqualify us, we have someone coming to receive these drives to ensure that that is all filtered out. We have
Oh,
no issue with
wow.
allowing the defense to review those drives prior to any of the prosecution team or certainly the court, if Your Honor wants to review them. We have no issue with doing that. And I think that's the
Kind of
appropriate thing now that we're here where we are. So we can ensure that there's no more of those text communications that can be reviewed. Concerning this document itself, again, it's been wiped from our servers. No one can access it, and I've been able to verify that. So that's why this does not go to the State v. Martinez case, and this is the Nunez case. Bless you. The other part is that Mr. Quinnen has been screened off the case, and that's why I created the analogy of this is different from the Popjoy case, which is a third DCA case from 1992. That case, the office that was taken off of the case, too small to be able to handle that situation. And so the dissemination of information was inevitable. That's not what this is. The Miami-Dade State Attorney's Office is one of the largest in the country, one of the largest in the state of Florida, possibly the largest in the state of Florida. We were able to screen Mr. Quinnen to where he doesn't have access to the electronic file. He doesn't have access to the hard file. He doesn't have access to myself or Ms. Hogue. And actually his office is on the far reaches of the state attorney's office to where we don't have to interact with him. So we're able to ensure that anything that he has seen, which the deposition shows that there really isn't any prejudicial information, would not come about or would be discussed with the current prosecution team. So that screening process is an important part and why there is no risk of future prejudice that the defendant might face. So, Your Honor, based on the arguments that I'm making, as the defendant sits here now, based on what Your Honor has deemed breaches, two separate breaches, or one separate breach, but two separate items, there is no actual prejudice as she sits here now with the current prosecution team, let alone the office itself. And then the risk of any future potential breaches or prejudice, we believe that we've taken proactive measures to ensure that that will not be a concern for this court or the defense team.
Yes. Your Honor, it's, how can I put this?
Ugh.
The credibility of the testimony by Mr. Quinnen that he just forgot. Right?
Right,
He
agreed.
forgot discovering the linchpin, the evidence that he needed to find the laptop, locate our expert. That is just that Your Honor can evaluate the credibility of those statements.
He's being a little dramatic, but it's okay, I guess.
What the state is trying, and just
He's
let's
trying to
talk more
defend
about
Courtney
what
Clay.
occurred. Mr. Quinnen disseminated that information to law enforcement.
He shared
His
it.
testimony was he didn't disseminate it to anybody else in the office. We know that the copy of that email was on the servers, but I do believe, and I do not doubt Ms. Hogue and Mr. Abhoff's representations to the court that they did not view it. But going back, the state's arguing that it's substantial misconduct has to have actual prejudice, but it's an or. And the quotes, I would say, are because the Downs versus Moore doesn't say prejudice. It says actual prejudice. That's the distinction of the quotes. It's an or situation. So for that substantial misconduct, we have to look at what the conduct was of Mr. Quinnen, and then again, the omissions, I believe, on the part of the two prosecutors. In the case of Nespler, which I think the state and the defense have argued in our written pleadings, I guess that's the beauty of the law. We're almost citing the exact same cases, but interpreting them differently. And then Your Honor has to figure out that who's wrong and who's right in a somewhat of a gray area. But Nespler, that's spelled with a K-N-E-S-P-L-E-R versus State 314 Southern 3rd 287. That's a 3rd district case. And they cite to one of kind of the staple Supreme Court cases that addresses this issue, which is State versus Fitzpatrick 464 SO2D 1185, Florida 1985. So
I don't know. Part of me thinks like, hey, they disqualified ASA Quinnen has stepped down or whatever. But then a part of me is like, and I'm thinking like, okay, they should just move on. But then a part of me is like, wait, no, they shared. Like, does it compromise? It means that everyone in that department is unethical. Yeah, to some extent, I feel like yes. No.
they talk about how the
No.
state is different than the law.
iffy, but
And they say there's a distinction between private law firms and government prosecutorial offices, and that's citing State versus Fitzpatrick. So as a result of that distinction, the Florida Supreme Court has recited that imputed disqualification of the entire attorney's office is unnecessary, meaning you can't do it or you shouldn't do it, when the record establishes that the disqualified attorney, who I would say here is Mr. Quinnen, right, has neither, one, provided prejudicial information relating to the pending criminal charge, which I think that's a tough sell, nor, meaning, and he also has not personally assisted in any capacity in the prosecution of the charge. Mr. Quinnen clearly, right, personally assisted in a whole bunch of capacities, right, in the prosecution of the charge. And again, that's, so what, why is disqualification of the entire office appropriate? Because he, Mr. Quinnen, personally assisted in any capacity in the prosecution of the charge. And that's at 1188 in the Fitzpatrick case. So, you know, we always, when I was in county court and we were all, you know, in county court, the judges, when it's DUI Mondays, there's the state, oh, judge, this isn't my case. This is ASA. So where's he? He's in the hallway, right? Well, you are fungible. That's what we used to always get. Well, you're fungible. You can go ahead and try this case, Mr. Prieto. So it's that distinction. The state is kind of considered their one fungible body. And that's what Fitzpatrick talks about, is that if, I believe it stands for the proposition that if the attorney that was disqualified participated in the case, that's it. You can do it. Right? So I think if you look at you know, the totality of the circumstances of the misconduct by act or omission, I think that your honor would be on solid ground And the third, if you disqualify the entire office.
Judge, if I could just clarification, no argument.
Wow.
For the
No argument.
disseminated to law
Whoa.
enforcement, that Mr. Quinnen, that was only specifically those law enforcement officers were on the computer case, is my
Mm.
understanding, and if defense knows otherwise, I believe it's just the
I believe that's
Miami-Dade.
correct. Yes,
Right, so that, and that's a different department than prosecuting the homicide. So I think that
Oh.
is also important to note, because that's also other screening that can take place, that there has not been discussions with those officers, as that case no longer exists. And the only other part would be that the Nespler case is a third DCA case that comes after the Nunez case, and Nespler does not discuss the Nunez case.
Yeah, they want to disqualify the
Call into
whole
question
office.
the Nunez ruling.
Judge, I do appreciate the state has tucked away Mr. Quinnen in the far reaches of the office. But you know,
He was stuck there before.
He's like, I know that you've tucked him away. He stepped down from that position. He didn't lose his job. He just
yeah,
stepped down.
well, you know, we have to rely that he's not going to speak to anybody. And I think that that's the fear that the client has. And we
He's
have
like,
as
we don't know if
defense
we
team
can
that
trust
nothing to
him
stop
after
the
that.
state,
I wouldn't trust him either, ma'am.
from,
Judge.
Well,
Ma'am, judge.
we'll end it there, Judge. I appreciate the court's time and the hearing, and
Right.
appreciate the state's arguments.
That's for transfer below. I think I took all the notes. Let me set it for my ruling. I want to go. It's gonna take me a little while to go through everything to write it all out. So let's get 30 days.
30 days. They're going to make a decision. Oh my God, I can't
Thank you,
wait.
Judge.
I've
Thank
been
you, Judge.
waiting for this case, the Courtney Clenny case. Wait.
I'm just gonna do 30 days to my ruling.
So would you like to do July 23rd?
So 30 days. Wait, did they say July 23rd?
So
Or
let's do June.
June. I'm sorry. June 20,
23rd might be on Monday too.
yeah, it is. June 25th is a Wednesday.
Okay, let's do Wednesday. Yeah,
June
do
25th.
Sounds good.
So the 25th, June 25th. June 25th, we will know more on Courtney Clenny. I mean, this happened in 2022. She stabbed her boyfriend in the hotel room. She's an OnlyFans model. She made like $2 million a year on OnlyFans. Yeah, and she claims that self-defense because her boyfriend and her were in a toxic, abusive relationship. I have a playlist. Go back and watch the body cam footage. Get caught up on this case because we're going to be covering it. I mean, I always stay covering it, but there was an incident last year where her parents got arrested for they allegedly tried to break into Christian, her boyfriend's computer to like get some information or delete something. That got dropped. And now they're looking to disqualify the whole office, the state prosecution office, because ASA Quinnen was sharing emails and looking at things he shouldn't have been looking at and sharing it in different departments regarding Courtney's defense strategy. So I'm curious to see when this trial will finally happen. She is an OnlyFans model. I don't know. Will she be found guilty? She's already done a bunch of time. She's looking, I think, second degree. And, you know, it's been a while. So I feel like, does that play a factor in the jury? Yes, I think so. But I can't wait for this trial. Been waiting. So thank you for being here. And we read through the response and we watched the hearing. We will stay caught up on June 25th to see what happens. Like, are they going to disqualify? I think it's second degree because it's self-defense. Not sure, Jules, but I thought it was second degree. Let me look because now I'm curious if I'm wrong. Yeah, second degree murder with a deadly weapon. Yeah, she stabbed her boyfriend and claims it was self-defense. And that's the trial or the hearing where, you know, they brought in the pig carcass and stuff. It's crazy. Make sure you watch the playlist. I've been wanting to kind of cover it again, but go back and replay. I have all the body cam footage. I do deep dive. She was awful to him. I hope she goes to jail for a long time. Yeah, I like for you guys to watch all that footage and see and make what you make of it, because it was a toxic relationship, but I also feel like there's no footage of him putting hands on her. And so I'm not saying she's lying, but I'm just saying not once did he even put hands on her. I don't know, but some people, one of their friends did say that he was a jerk to her behind, when no one was watching. So I don't know. But I definitely think she was making $2 million a year. She could have got her shit together a little more. Right. But anyways, thanks for being here. I have another live right after this. We're going to marathon Karen Reed, Melly After Dark, Buzzball time. Make sure you show up, hit the like button, subscribe, do all them YouTube thingies, please. I have a deep dive tomorrow that I'm really excited about. Hopefully I can finish up editing it. I'm really, really excited to cover this case. I've already kind of introduced it on my channel on an After Dark a few nights ago. So I'm really excited, and it's a holiday, so we're going to have a fun night. Hopefully I can see some of you there. Shout out to my mods for being here, and I will definitely see you guys shortly on the next one. Bye.